Welcome back to the deep dive. We take those dense regulatory documents, the ones you need to understand, and we try to break them down, make them usable.
Make them make sense, right?
Exactly. And today, we're heading into the world of Jamaican real estate. It's intricate, definitely. We're focusing on something that trips up, well, almost everyone at some point.
Yeah, we're looking at the edges, the boundaries. Real estate rules, especially for selling and developing property, they're vital. Absolutely critical for trust in the market.
No question.
But, and this is the key thing, these rules, sometimes pretty strict rules, they don't apply to everyone.
And that's our mission for this deep dive. We want to give you a shortcut, basically, a clear path to understanding who gets a pass, legally speaking, within Jamaica's real estate system. So if you're just curious, maybe thinking about selling your own place, or you're new to the business, or even if you're a seasoned realtor needing a quick refresh on who needs what, this is for you.
We're digging into the specifics, looking right at the text outlining exemptions under Jamaica's main law here, the Real Estate Dealers and Developers Act. You'll usually hear it called REDDA.
Okay, REDDA. Let's unpack that then. Who is exempt from these dealing and developing rules in Jamaica? And maybe just as important, why are they exempt? What's the thinking there?
It's actually quite fascinating when you look at it. It's all about balance, really. The law is trying to protect consumers. That's REDDA's main job, right?
Sure, protect people from bad actors.
Exactly. But it also has to allow for, necessary life stuff, managing personal affairs, handling legal duties without throwing up massive roadblocks. It's recognizing the difference between running a real estate business and fulfilling a specific, often temporary, legal role.
Okay, before we jump right into the exemptions, maybe we should back up just a tiny bit. To really get why being exempt matters, we need to know what REDDA actually requires from everyone else. What's its basic job?
Right, good point. So REDDA is really the foundation for professional real estate in Jamaica. It's the key law managing the sector.
Managing and policing, you said.
Yeah, in a sense, it mandates that anyone whose business involves dealing with property for others, selling, buying, leasing for a client, needs to be registered. Licensed. Same goes for developers, people building properties to sell.
So it targets the professionals.
Yeah.
The people doing this as their job.
Precisely. And getting that license isn't just filling out a form, it means meeting standards.
Like what kind of standards?
Well, professional qualifications. For one, you need to know what you're doing. There's a code of conduct you have to follow. And really importantly, there are financial rules. Things like how client money is handled in trust accounts. It's all about ensuring accountability.
Accountability and, I guess, a certain level of confidence. You want to know the person you hire is legitimate.
That's the core idea. It sets a baseline standard, protects the public, maintains market integrity. If everyone doing this for a living follows the same stringent rules, it elevates the whole profession.
Makes total sense. You want that protection.
Absolutely. But, and here's where we get to the heart of today's discussion, REDDA itself says, okay, these strict rules apply to the pros, the commercial players, but
There's a but.
There's a but. The Act specifically carves out exceptions. It lists certain people, certain situations where the transactions involving property aren't really seen as a commercial business venture.
Which brings us back to the why. Why create these exceptions at all? Why not just make everyone register?
Well, think about the burden. Imagine someone just needs to, say, sell their deceased parent's house as part of settling the estate. They're acting under a legal duty.
Right, they're not suddenly deciding to become a real estate agent.
Exactly. Forcing that person to go through full real estate training, exams, registration. It's not practical. It's overkill. And frankly, it could slow down or even block the very legal process they're supposed to be completing.
So it would actually get in the way.
It could. The law recognizes that sometimes dealing with property is just a necessary function, part of life, part of legal processes, not always a business. The exemptions ensure those necessary functions aren't unduly hampered.
Okay, that logic holds up. It's about differentiating roles. So let's get into the first big group of exemptions, the ones where people are acting because someone else or the law itself told them to. Right, this first category, it seems like it's all about people who didn't just decide to sell property, but were given the authority, or maybe even ordered to do so. Their power comes from somewhere else.
That's a good way to put it. Their authority isn't commercial ambition. It's derived from a legal source. Hashtag tag 2.1, acting under legal appointment, power of attorney. And the first big one here is someone acting under a valid power of attorney, a POA. This is a really common tool, especially for property matters.
Okay, power of attorney. Most people have heard of it, but maybe just a quick refresher for anyone unfamiliar. What does it let someone do?
Sure, a POA is a legal document. The principal, the property owner, usually gives legal authority to someone else, the attorney or attorney in fact.
Not necessarily a lawyer, right? Just the person given the power.
Correct. Could be a family member, a trusted friend, and that power could be broad or very specific, like just managing finances or, relevant here, handling property matters. It's often used if the owner is overseas, unwell, or just unable to manage things themselves.
So let's say my aunt lives abroad. She gives me a valid POA to sell her house in Jamaica. I find a buyer, sign the papers using the POA. I don't need a REDDA license for that specific act.
That's right. The person holding that valid POA is exempt from needing to register under ADA for the purpose of completing that transaction on behalf of the principal.
Okay, but you emphasize completing the transaction. Is there a catch?
Well, it's a nuance, especially for realtors listening. The exemption covers the POA holder's legal ability to sign and act for the owner. It doesn't suddenly turn them into a licensed real estate dealer. Meaning, they probably shouldn't be the ones out there actively marketing the property, holding open houses, negotiating complex deals as if they were a realtor. That's not what the POA exemption is for.
Ah, okay. So the POA holder might still hire a licensed realtor to do the actual selling part, the marketing, finding buyers, handling the viewings.
Exactly. That's very common. The realtor brings their expertise, their license, handles the professional side. The POA holder provides the legal signature, the authority granted by the principal.
That makes the division clear.
And it highlights why the exemption exists. The POA holder is performing a duty, often a fiduciary one. They're acting for someone else, not setting up their own real estate business.
Got it. And for a realtor working with someone who has a POA?
Verification is key. You absolutely need to see that power of attorney document. Confirm it's valid, properly signed, witnessed. And crucially, for land transactions in Jamaica, certain POAs need to be stamped and recorded or lodged with the titles office to be effective for the actual property transfer. Checking that documentation is the realtor's job, not demanding the POA holder gets a REDDA license they don't need.
Right. Verify their authority, not their license. That's a practical takeaway. Hashtag tag 2.2, acting under judicial order.
Okay, so moving from authority given by a person, POA, to authority given by, well, the courts. The next exemption is for individuals acting under a court order.
A direct order from a judge. That sounds serious.
It usually is. These individuals are also exempt from REDDA requirements.
When does this typically happen? When would a court step in and tell someone to manage or sell property?
It happens in various situations where there's a legal need or maybe a dispute. Think about managing property for a minor, someone who can't legally manage it themselves. The court might appoint a guardian. Or, sadly, during contentious divorces where assets need to be divided or sold, sometimes in debt recovery cases or other lawsuits, the court might order a property sold and appoint someone specific to handle it.
So the person appointed might not have even wanted the job.
Quite possibly. Their role is mandated by the court. The court's authority is paramount here. So the exemption makes sense because the court itself is overseeing the process.
And the person isn't choosing to enter the real estate field. They're just following a legal directive.
Precisely. They have to comply, or they could face contempt of court charges. It's not a career choice. It's a legal obligation.
And trying to make them get a REDDA license first would just slow everything down, right?
Yeah.
Especially if the court order is urgent.
It would create unnecessary friction, exactly. The legal system needs to be able to function. The exemption recognizes that a court order takes precedence over needing a separate professional license for that specific court-mandated task. It ensures legal obligations can be met efficiently.
Okay, this next group feels like one that people, maybe especially realtors, run into quite often. Dealing with estates, bankruptcies. We're talking about administrators, executors, receivers, and trustees.
Yes, this is a really important category. All these roles, when they're acting in their official legal capacity regarding property, are exempt under a REDDA.
They all sound kind of similar, managing assets for others. But let's break them down. Maybe start with the ones handling affairs after someone passes away. Administrator and executor.
Right. So an executor is the person named in a will by the deceased. Their job is to carry out the instructions in that will. That often involves managing the estate's assets, paying debts, and distributing what's left, which frequently means selling property.
Okay, appointed by the will itself. What about an administrator?
An administrator does basically the same job, but they're appointed by the court. This happens when someone dies without a valid will, which is called dying intestate. The court steps in to appoint someone to manage and distribute the estate according to the law.
So, executor chosen by the person, administrator chosen by the court, but both are managing the deceased's property as part of settling the estate.
Correct. And their authority usually comes from a formal court document, letters testamentary for an executor, letters of administration for an administrator. Their role regarding the property is specific. Manage it, maybe sell it, and distribute the proceeds as required by the will or the law.
Not become a property mogul.
Definitely not. It's a defined, limited function. Now, the other two you mentioned deal more with financial situations or long-term asset management. The receiver and the trustee.
How are they different?
A receiver is usually appointed when there's financial trouble. Think foreclosure, bankruptcy. A court, or sometimes a creditor, like a bank holding a mortgage, might appoint a receiver to take control of the property. Their main job is often to manage or sell the asset quickly to pay off debts.
So more of a crisis management role. Often.
Often, yes. A trustee, on the other hand, manages assets held in a trust. Trusts are set up for longer-term purposes, maybe managing assets for minors, for charity, or complex estate planning. The trustee manages those assets according to the rules set out in the trust deed, acting for the beneficiaries. Selling property might be part of their duties, but it depends entirely on the terms of that trust.
Okay, 4 distinct roles. Executor, administrator, receiver, trustee. They get their authority in different ways.
Yeah.
But what's the common thread? Why are they all exempt from REDDA?
The common thread is that their actions are fundamentally fiduciary and legally mandated or defined. They have a strict legal duty to act only in the best interests of someone else, the estate beneficiaries, the creditors, the trust beneficiary.
And crucially,
They are not doing this as a commercial real estate business for their own profit in the typical sense.
now hold on. Don't executors sometimes get paid, like a percentage of the estate? Doesn't that sound like profit? That seems like a point professionals like realtors working with them need to understand clearly.
That's a really sharp point, and it's where the distinction matters. Yes, fiduciaries like executors or administrators can receive compensation. It's often set by law or the court, sometimes as a percentage. But the law views this differently from a real estate sales commission.
How so?
It's seen as payment for the service of administration, the complex legal and financial work involved in managing and settling the estate or trust. It's compensation for fulfilling a legal duty, managing paperwork, dealing with beneficiaries, paying debts. It's not a commission earned from actively marketing and brokering a property sale in the open market like a licensed dealer does.
So the payment is for the administrative burden, not for the act of selling itself.
Essentially, yes. Their role is legally defined, finite, and focused on that fiduciary duty. They aren't building a client base or running a brokerage. That's why the exemption holds. They aren't operating as professional real estate dealers in the way REDDA defines them. And realtors need to respect that boundary.
Okay, that clarifies that potential confusion. So this whole first category, POA holders, court appointees, fiduciaries, they're exempt because their authority comes from a specific legal source, overriding the need for a commercial license for those specific duties. All right, let's shift gears. Category 2. These folks aren't necessarily acting under a legal mandate like the first group. It seems this category is more about, well, either they're already regulated heavily elsewhere or they're just acting for themselves. Is that right?
That's a good summary. It's about avoiding redundant regulation and also recognizing basic personal rights. Hashtag 3.1, the already regulated professional attorney at law. First up in this group, licensed attorneys at law. Lawyers. They get an exemption from REDDA, and this is important only when they're doing certain specific things related to property.
Okay, and like you hinted, this is probably because they already have their own regulatory body, right? The General Legal Counsel in Jamaica.
Exactly. Why have two different bodies regulating the exact same activity? The key, though, is the scope of the activity the exemption covers.
So what is covered for lawyers?
It primarily covers the activities that are traditionally part of their legal practice concerning property. The big one is conveyancing.
Conveyancing, that's the legal process of actually transferring the ownership.
Precisely. It's all the legal steps. Checking the title is clean, drafting the sale agreement, preparing the transfer documents, handling stamp duty and registration, making sure the whole deal is legally sound. That's core legal work. The exemption also covers giving legal advice related to the transaction.
Okay, that makes sense. That's lawyer territory. But what's not covered? This seems crucial for everyone, especially realtors, to understand.
What's not covered is acting like a real estate broker or dealer.
Meaning?
Meaning, if an attorney starts, say, listing properties for sale publicly, actively marketing them, holding open houses, trying to find buyers, negotiating the price as a broker for a sales commission,
They've crossed the line.
they've absolutely crossed the line. At that point, they're engaging in the business of real estate dealing, not just providing legal services. And for that activity, they would need to be registered separately under REDDA, just like any other realtor.
So the exemption is purely for the legal mechanics of the deal, not the commercial matchmaking.
Exactly. It stops them from needing two licenses for the same core legal function they're already highly regulated for by the General Legal Counsel. It respects their existing professional standards.
Okay, so when a realtor and a lawyer work on the same deal, which is pretty much always,
The roles are clear. The realtor handles the marketing, finding the buyer, the negotiation perhaps. The attorney handles the legal due diligence, the contracts, the transfer. Both professionals, both regulated, just under different acts for their distinct roles.
got it. Clear division of labor, clear lines of regulation. Hashtag tag 3.2, exercising personal rights, property owner.
All right, now for maybe the most straightforward exemption, but one with some hidden complexities. This is the exemption for a property owner dealing with their own land.
This seems pretty basic. If I own my house, surely I can sell it without needing a license.
That's the fundamental principle. If you, as an individual, own property, your house, a piece of land, and you want to sell it yourself, lease it out yourself, manage it yourself. You don't need to register as a dealer or developer under any DDA?
It's just exercising your right as an owner.
Exactly. The law recognizes that people need to be able to manage their personal assets. Imagine the chaos if every single person selling their home had to get a full real estate license.
The market would grind to a halt.
Pretty much.
Yeah.
So the exemption ensures that freedom. Manage your own stuff without that extra layer of professional registration.
Okay, that seems simple enough for, say, selling one house. But you mentioned hidden complexities. Where does it get tricky? Especially thinking about people maybe doing more than just selling one home.
This is where it gets really important, especially for people getting into property investment or maybe small-scale development, and certainly for realtors advising them. The line blurs when an owner's activities start looking less like managing personal assets and more like running a real estate business, specifically development.
Right. Where does selling my land stop and acting as a developer begin, even if it's my own land?
This is where the source material strongly advises getting legal advice if things get frequent or complex, because the regulators will look at the pattern and nature of the activity.
Okay, walk us through an example.
Let's say you inherit a big 10-acre plot of land. If you just sell that whole 10-acre plot as one piece, exempt, you're just disposing of an asset you own.
Simple enough?
But what if you decide to hire surveyors, get approvals to subdivide that 10 acres into, say, 20 half-acre residential lots? Then you put in roads, maybe basic utilities, and then you start marketing and selling those 20 individual lots to the public.
Wow, that sounds different.
It is different. At that point, REDDA would very likely say you are acting as a developer, even though you owned the original land.
Why? What changed?
What changed is the activity. You're no longer just selling what you owned. You are actively creating new real estate inventory, the subdivided lots, specifically for sale to the public, for profit. You've added value through infrastructure, the frequency, the intention to profit from creating multiple units, the scale. It shifts from personal asset management to commercial development.
So the activity defines it, not just the initial ownership.
Exactly. It's about the nature of what you're doing. Are you consistently transforming land and creating units for sale? That's development. This prevents someone from buying large tracts, doing major subdivisions, and claiming they're just selling their own land to avoid registration. It closes that potential loophole.
That's a critical distinction, especially for anyone thinking about flipping properties or subdividing land. You need to know when you cross that line. Hashtags tag 3.3, the operational manager, condominium complex.
Okay. The last specific exemption we need to cover is a bit more niche, but important in certain contexts. It's for someone employed as a manager of a condominium complex, or what's often called a strata corporation in Jamaica.
Right, the person running the day-to-day stuff at the condo building. But you mentioned a key limitation here before.
Yes, and it's very strict. This exemption only applies if their duties are limited to renting individual units within that specific complex where they are employed.
Only renting. and only within that building.
Correct. They're essentially acting as an internal rental agent for the owners within that strata or for the overall owner of the complex. They're managing the building's operations, making sure units are occupied, handling tenant issues for that property.
So it's seen as operational management, not general real estate dealing.
Exactly. Their work is focused inward on that one asset. It's considered property management, keeping the place running. It's very different from being an independent realtor who lists properties anywhere, or even if that same manager tried to handle the sale of a unit in their complex for an owner, or rent out a property outside the complex.
If they do any of that broader stuff, they'd need a license.
They would absolutely need a REDDA license. The exemption is narrow, internal rentals for the complex that employs them, period.
Okay, it fits the pattern then. It's another case where the law sees a specific necessary function managing the building's rental operations and decides not to burden that internal role with the regulations designed for external market-facing brokers.
That's the theme, isn't it? In every single exemption we've looked at, whether it's Category 1 or 2, the common thread is the activity isn't seen as standard commercial real estate brokerage or development. It's either mandated legally, already regulated elsewhere, a basic personal right, or a very specific internal operational role.
Wow, okay. That was a lot of detail covering those 6 exemptions: power of attorney, court orders, the fiduciary's executor, administrator, receiver, trustee, then attorneys doing legal work, property owners selling their own stuff, and condo managers doing internal rentals. Let's try and pull it all together. What's the big message here? What connects all these seemingly different exceptions?
I think the main takeaway is seeing how Jamaica's real estate law tries to be quite sophisticated, quite nuanced. It recognizes that not everyone touching a property transaction is doing it as a business.
Right. The common thread seems to be the non-commercial nature of the role, at least in the eyes of this specific law.
Exactly. These exemptions carve out space for actions driven by legal duty, like an executor, personal necessity, like using a POA when ill, existing professional roles, like attorneys doing conveyancing, or fundamental rights, like selling your own home. The law basically says these specific situations aren't the commercial marketplace activities that REDDA was primarily designed to regulate.
So it's all about drawing a line. On one side, you have the open market, commercial dealing and development that needs the strict REDDA rules for consumer protection.
Definitely. Market integrity depends on that.
And on the other side, you have these specific, often legally defined or personal situations where imposing those same rules would be impractical or even obstructive.
That's the balance the law is trying to strike. Allow necessary legal and personal property matters to proceed smoothly while still keeping a tight rein on the professional marketplace itself.
Okay, let's make this super practical. We wanted this for laypersons, newcomers, and realtors. What does knowing all this do for them? Let's start with the everyday person, maybe someone inheriting property or selling their house.
For them, this knowledge is, I think, really empowering. It demystifies things. If you're named executor in a will, you now understand, okay, I have a legal duty and I'm exempt from needing a realtor license to fulfill that duty. If you're selling your own family home, you know you have the right to do that directly. It clarifies your rights and responsibilities.
Remove some fear, maybe. Fear of accidentally breaking a rule.
It should. It helps define when you can act on your own or through your lawyer. And importantly, when you do need to bring in a licensed REDDA professional because you're crossing into commercial activity.
All right. Now, for the professionals listening, the realtors, the developers, maybe even the lawyers, what's the key takeaway for them? Why do they need to know these exemptions inside out?
For professionals, this is about compliance, efficiency, and frankly, avoiding big mistakes.
How so?
Well, imagine a realtor gets contacted by someone saying, I'm the executor for my mother's estate, I need to sell her house. If the realtor doesn't understand the exemptions, they might mistakenly think, uh-oh, this person isn't licensed, and either refuse the business or give incorrect advice.
Wasting time and potentially losing the listing.
Exactly. Knowing the exemptions means the realtor understands, okay, this person is acting under a fiduciary exemption. My job isn't to check their license, it's to verify their authority as executor.
Right. You mentioned verification earlier. Can you give another concrete example? What should a realtor actually ask for?
Absolutely. If dealing with an executor, you need to see the grant of probate or letters testamentary. That's the court document proving their appointment. If it's an administrator, you need the levers of administration. If it's a power of attorney, you need to see the actual POA document, check its scope, check if it needs to be registered for land deals. Your due diligence shifts from checking for a REDDA license to verifying the legal document that grants the exemption.
That's a very practical shift in focus. It means you can confidently work with these exempt parties, knowing they are operating legally within their specific roles.
Precisely. It smooths out the process for everyone. The realtor meets their compliance needs by verifying the correct authority, and the exempt individual can fulfill their duties without unnecessary hurdles.
This loops back perfectly to that warning note from the source material, the advice about seeking legal counsel when things get complex, especially around the property owner exemption, right?
Yes, that's probably the area with the most potential for accidentally crossing the line. As we discussed, the difference between selling one inherited property and actively subdividing and selling multiple lots is huge in the eyes of the law.
So if someone is doing multiple deals, maybe fixing and flipping, or starting to look at subdivision,
They really need to talk to a lawyer who understands ODA. Don't guess, because the regulators won't just look at one transaction, they'll look at the pattern. Are you acting like a business? Is this frequent? Is it development?
and the consequences of getting that wrong could be severe, I imagine. Fines, legal trouble.
Definitely. Operating as an unlicensed dealer or developer when you should be registered carries significant penalties. It's far better to get clear legal advice up front to determine if your activities still fall under the personal owner exemption or if you've crossed into territory requiring registration. Understanding that boundary saves a world of trouble down the road.
Know your status. That seems to be the ultimate takeaway. The exemptions provide clear paths for specific roles, but if your activity starts looking like a regular business, get advice. #tag outro. Okay, that was incredibly thorough. A real deep dive into who gets a pass under Jamaica's Real Estate Act, REDDA. Just a super quick recap. We covered those acting under power of attorney, those acting under court orders, the fiduciaries, executors, administrators, receivers, trustees, attorneys doing conveyancing work, property owners dealing with their own land with that important development caveat, and condo managers renting units internally. 6 key groups.
And seeing them all laid out like that, it really highlights something interesting about how regulation works, doesn't it?
How do you mean?
Well, look at the reasons for these exemptions. Some are about personal rights, like owning property. Some are practical, like the condo manager role. Some are mandated by courts. And some, like the attorney exemption, are about deferring to another existing robust regulatory system, the legal profession's own rules.
Right, it's not just one reason, it's a mix.
Exactly. And it makes you think, how much of real estate regulation, like REDDA, is about setting up brand new rules specifically to police the marketplace and protect consumers from unique real estate risks? And how much is actually about the law recognizing and coordinating with other existing forms of governance, court orders, fiduciary duties, professional licensing bodies?
That's a fascinating question. Is it building a new fence or just making sure the existing fences are recognized and connected properly? It suggests maybe the goal isn't always more regulation, but smarter regulation that acknowledges the whole legal landscape.
Something to definitely mull over, especially if you're navigating these complex transactions. It changes how you see compliance. Sometimes it's about following REDDA, sometimes it's about proving you fall under a different but equally valid legal authority.
A great final thought. Thank you for joining us on the deep dive as we explored these crucial exemptions in Jamaican real estate law. We hope this helps you navigate the market with more confidence. Keep exploring.